She made it seem like he was already guilty.
All right?
That should be a problem for the court. It absolutely should be a problem for the court. I have a problem with this. If you're agreeing that she made statements to jurors, and he's probably going to say that one of the jurors said it did affect their verdict, why aren't you giving them a new trial? I personally think there's enough there to warrant a new trial.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. Guess who I am? I'm Bruce Rivers. Guess what I am? I'm your board-certified criminal defense lawyer. Why does that matter? It matters because when I give you some analysis, it's through the lens of an expert in the area of criminal law. I try cases all the time. On Tuesday, I'm going to trial on a homicide. This is what I do. And so, and I've been doing it for 26 years. But I'm never so good as when I'm with my content genius. And your content genius, Michael Rivers. So we're coming to you today with our pearl handle pistol cufflinks all ready to go, fired away at the Alec Murdaugh trial. Now, he's filed a motion for a new trial, but before we get to that, what are we brought to you by? Brought to you by eForms.com. eForms.com is a very effective way to avoid dickheads like me. I am a lawyer, and I charge a lot of money for the things that I do. So if I create a form for you so you can just sign it and be protected by law, I'll charge you a lot of money to do that. Let's say, for the sake of example, that you're accused of murdering your wife and son, and you need to have somebody on the outside take care of your business. Well, you go to eForms.com and you get a power of attorney. There's all kinds of documents that even Alec Murdaugh can access, so you can do business. You can be protected by law, but you don't have to pay a lot of money because you don't have a lot of money because you're doing prison. You just killed 2 people. Anyway, but honestly, all kidding aside, it is really an effective way to get any kind of business done without using a lawyer and be protected by law. eForms.com. All right, so the defense in this case made a motion for a new trial. And the motion for a new trial was based upon the misconduct of the clerk of court. And the clerk of court, apparently, the allegation is that she told the jurors, something about Alec Murdaugh's testimony. Like, he's going to testify, he's guilty, blah, blah, blah. Who knows if she actually said it? But it's a real high burden to get a new trial because you have to show that it's kind of a but for. You ever hear the term but for? But for the actions of this clerk, there wouldn't have been this verdict. So let's hear what the judge has to say.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions? What else?
First of all, a clerk of court shouldn't be having any fucking communication with the jury about anything substantive. All they talk about should lunch, going to the shitter, taking, a smoke break, or that kind of stuff. They should not be talking about this case at all. For a verdict to be respected, it's got to have integrity. And when you do this kind of shit, and then she writes a fucking book later. I mean, who does that? And then later on we hear from 2 clerks talking that she needed a new cabin. What? That's why she wrote a book, because she needed a new cabin? Come on. It just stinks to high heaven.
To watch him closely.
To watch him closely. Anything else you remember?
There is, but I can't remember.
Okay, that's fine.
That sucks for the defense. There is, but I can't remember. And the judge isn't about to browbeat her into trying to remember. But to watch him closely, I think the allegation was more like, watch him closely, he's going to be guilty, blah, 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 something of that nature. But in this case, there was really a lot of evidence. I mean, a lot of evidence that he's the only other one there So generally speaking, if you're the only one there and there's two people dead and there's no evidence that anybody else is there, guess what? Grab your ankles. It's time to pick up the soap.
And was your verdict on March the 2nd, 2023, in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
That is the quintessential question. If she can't answer yes to that, then there's no new trial. Because even though there may have been some misconduct, it has to be so bad that the verdict would have been different otherwise.
Yes, ma'am. Yes, please.
All right. Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
So it seems like we're halfway home. If this juror says her decision was somewhat influenced or was influenced by this clerk, I think that should be a problem for this court. When the court looks at a motion, any kind of motion, it's viewed in a light most favorable to the opposing party. That's just the way they are. So when the court takes this motion, the court looks at all the filings and all the evidence and everything in a light most favorable to the state, because they're the non-moving party. That's how it is for every motion.
To me, it felt like she made it seem like he was already guilty.
All right.
That should be a problem for the court. It absolutely should be a problem for the court. I have a problem with this.
And I understand that. That's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
But second time this judge has asked that question. First time she said yes.
Yes, ma'am.
Okay, it's probably a woman.
Yeah.
I thought it was a guy this whole time.
Time did you instruct the jury to watch him closely and look at his actions?
I did not.
At any time did you instruct the jury or tell the jury to look at his movements?
No.
At any time as the jury moved to deliberate, did you tell the jury this shouldn't take long?
No.
These are pretty standard questions that you would expect them to ask, and you'd expect these responses.
At any time did you tell the jury that the defense case, watch out for the defense case, they're going to try to throw you off, or anything along those lines that was meant to influence the jurors against Mr. Murdaugh?
No.
Hill was also asked whether she had conversations with the foreperson, something the defense claims happened many, many times throughout the trial, including during a tour of Moselle.
During the time that you were on the property, traveling there, traveling back, did you have any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
No.
This has just got to piss off the court and piss off the prosecutor, because first of all, she shouldn't be writing a book about this. This is her job, and she's doing a for-profit, opportunistic thing, and she's calling into question the integrity of the court, because she is part of the court. She's an officer of the court, just like the lawyers are. And it really calls into question the integrity of the verdict, of the court, and it creates a lot of problems for everybody involved.
Did you have a quick comment to the forelady about how the property was beautiful and there were tea olive trees there that bloom and smell good, or words to that effect?
I did.
She shouldn't be having any conversation whatsoever with the jury. It's inappropriate, and it leads to shit like this.
Let's talk about this book for just a second. When did you first decide you were going to write a book?
I think a thought was there, a very fleeting thought, before the trial.
Did you take any steps before the trial or at the initiation of the trial to begin writing this book or working with somebody on this book?
Oh, no, sir.
When did you and your co-author get together?
It was several weeks after the trial.
Okay. Did you talk to anybody about the fact you were going to write a book before the trial?
There were several.
She just looks bad here. It looks terrible.
Anchors and several journalists that I did speak with about the possibility of writing a book.
Now, did you ever tell her that you had given a juror a ride home, that you had accompanied Mr. Bill, what's his last name?
Bill Polk.
Right. That you and he took a juror home one night? Did you tell her that? Did you take a juror home one night?
I didn't take a juror home one night.
Did
No,
Mr.
sir.
Mr. Polk and you take a juror home one night?
No, sir, we
Okay,
didn't.
you never gave a juror a ride in a car with Mr. Polk or without?
No, sir.
Justice Toll actually questioned Becky Hill quite extensively, actually impeaching her on some of her testimony and prior statements.
Well, in your book, you suggest that the guilty verdict was what you wanted, and you were fearful that that a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
That's an issue. I mean, you're supposed to be unbiased. You know, the clerk is supposed to be unbiased. You know, and we all have their feelings. You know, a court reporter, and they're taking everything down. They see how the evidence comes in. They have their opinions. Clerk has their opinions. They need to keep that shit to themselves.
I do agree that that is said in the book. And part of that is because I think it was a guilty verdict.
Well, this is that you were describing a time way before the verdict was rendered when you wrote about those things in the book. Isn't that correct?
It is, yes.
And you even have something where you say that your eyes met with jurors.
Think about this. You're the clerk of court. You are charged with ensuring this is a fair process. You can have your opinions, but they shouldn't be made known. You're putting your fingers on the scales of justice.
And others at Moselle, and y'all have an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary, the word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more apparent.
In other words, I just got to sell some books. That I just don't like it. This just has a real smell to it, bad smell.
But at no time did I read or try to read someone else's eyes, and that was just one of those gut feelings that I wrote in the book.
Then the defense called a witness who said that guilty verdict was not just a gut feeling by Becky Hill. It was something she actually wanted to help sales of a book that she had planned to write. Rhonda McElveen is Barnwell County's clerk of court who helped Hill with the Murdaugh trial.
Before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir.
Which completely contradicts her testimony.
Wanted to write a book. Yes, sir.
Wanted to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what if anything did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis in reference to the book? What would help the book?
A guilty verdict.
Did you have a discussion with the clerk, Becky Hill, about her being with jurors on her own?
Yes, sir, I did. One morning I showed up to Colony County, and I was told that she had taken a juror home the night before. And I was in the courtroom when I saw her, and it was between the pews and where the back row pews are. And I mentioned to Miss Becky, I said, please tell me you didn't take a juror home last night. And she told me, she says, I did, but I didn't talk about the case. I had a bailiff with me. Mr. Bill was with me.
That totally contradicts her testimony, the clerk's testimony. Now, my understanding is later on the judge finds her not credible. and you got a juror who says that she's been affected. You've got a clerk who's been deemed not credible. And you've got somebody who said she's having all kinds of contact with these jurors.
I said, Becky, you don't do things like that. I thought
She's 100% right. You don't do things like that. You go overboard to make sure of the propriety of the process, because otherwise it's tainted. And it sounds like it's tainted here.
we had stopped everything. It wasn't far enough along to really cause a major problem, or I would have told Judge Newman. But I thought we had to understand that you did not spend time alone with the jurors.
Okay.
A little bit about, well, let me ask you this. So there are all these conversations going on, and that's natural. That happens, private conversations with court staff behind closed doors. But you never once saw or observed or had anyone tell you that any of those conversations were being shared by Miss Becky with any juror. Is that right?
That is correct.
All right. And if that had happened, if you had observed anything untoward or improper going on at this particular trial, you would have immediately gone to Judge Newman as part of your obligation. Is that correct?
That is correct.
So sometimes when you have a motion, you take testimony, and then it's like, okay, now that we have the testimony, let's brief the issue. So the judge will take it under advisement. They'll set a briefing schedule. You get a transcript of what happened, that you can properly vet, anything that's in the transcript and refer to it in your memorandum. The judge didn't do that in this case.
Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness.
That's a fucking problem. The clerk of court was not credible. I wonder if she still has her job. I mean, this would be grounds for dismissal. Just writing the book would be grounds for dismissal if I was the court administrator.
Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. So,
if you're agreeing that she made statements to jurors, and he's probably going to say that one of the jurors said it did affect their verdict, why aren't you giving them a new trial? I personally think there's enough there to warrant a new trial.
Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath.
So one of the things that this juror did say is that she felt pressured by the other jurors. That's never a reason to overturn or grant a new trial, overturn a verdict or grant a new trial. That's what jurors do. We need to get out of here. Let's just find this guy guilty and go home. There's some of that going on. Of course there is. And if there's pushback here and there, so of course you're going to have a little bit of that. But, so that by itself isn't. But this tainting the jury by talking to them, by expressing a preference for a guilty verdict, if she in fact did that, I think that it warrants a new trial.
These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect.
But one juror said they did. That should be enough.
One juror was ambivalent in her testimony.
So here's where it sits. So the judge denies their motion. Now they take that, along with any other issues that happened during trial, and they throw it up to the Court of Appeals. If the Court of Appeals denies it, they go up to the Supremes. If the Supreme denies it, then they go to the Circuit Court of Appeals federally. They file what's called a writ of habeas corpus. That doesn't work, then they go up to the Supremes. So there's a few more avenues that they have, but let's hear what they have to say.
That was very heartening today there are two things. The first is that Judge Toll found Becky Hill to be a liar. Okay, that's number one, which means
what do you call it? Siren what?
Seduced by the sirens of celebrity.
She was seduced by the sirens of celebrity.
we met our factual burden. Two, she made it very clear that the law in this area is unsettled at best, and that it means it's ripe for appeal. So the facts are settled. Becky Hill's not credible. The judge found, in fact, that the statements were made to the jurors.
I think that the statement made to the juror was not as ambivalent, or the one juror's reaction was not as ambivalent as the judge claims. And the judge, if they side with the prosecution, that's the safe bet, right? Because they didn't let a murderer go. But
she just found that we couldn't show prejudice, but conceded that we may not have to show that if she's wrong about the law and the law's unsettled.
So even if he gets a new trial and something happens with this case, he still has 27 years to do on the fraud charges, where he ripped off all of his clients. I mean, fuck. And that's consecutive to the life sentence he got on this. So, he's going to appeal his conviction, but he's also going to appeal his conviction based upon, other things, not just this one thing with the clerk of court. But this is kind of a huge deal. And I think that the defense has met their burden in this. I really do. And I would not be surprised if the Court of Appeals reverses this judge's ruling. So this is just our little reaction to the Murdaugh motion that was denied. But stay tuned, because I think we're going to see something a little bit different coming down the pike. I think the Court of Appeals might look at this and say, I think the defense has met their burden. And you know what? Even though you take this motion in a light most favorable to the state, you want the integrity of the process to be so fair that you don't want to abridge any rights of the defendant, because we go overboard for defendants' rights, right? And we should, because if they can just if they can violate your rights, they can violate my rights, your rights, anybody else's rights, and not have to really answer for it. So it wouldn't surprise me at all if this wound up getting retried. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers, your criminal defense lawyer, board certified, along with our content genius, Michael Rivers. Make sure you subscribe, follow us on Instagram, follow us on Twitter, and make sure you visit eforms.com. See you next time.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please, is that my God.